All this became possible.
It's not my personal morals in terms of how you judge the situation, it's the law, and the law allowed quite a bit.
While Diane Beaver's legal advice was apparently withdrawn in 2003, it was June 2006 before the US Supreme Court ruled that all Guantanamo detainees were entitled to the protections of the Geneva Convention. The President had acted unlawfully. Mr. Bush then granted those who've been involved in the interrogations domestic immunity. This, it's claimed, creates another problem. It leaves interrogators and lawyers vulnerable to international prosecution for any alleged abuses of detainees. Philippe Sands is an expert in international law.
There's an established principle that, and it's a very sensible principle, that it's first and foremost for the jurisdiction in which the act occurred, principally, to investigate and, if necessary, to prosecute. If the domestic jurisdiction, in this case the United States, has closed off that possibility by creating a blanket, apparently watertight immunity, then there is not only an incentive, but some would say an obligation on others to investigate.
The precedent is Nuremberg, where Judge Joseph Alstotter was the first lawyer defendant. Documents from his trial show how Alstotter was signing legal papers in 1944, saying he couldn't reveal where Jews had been deported. He cited security reasons. Philippe Sands says the Bush administration also cited security reasons for ditching Geneva and for the alleged abuses which followed.
I'm not for a moment saying that the actions of the Bush administration are analogous to the actions of the Third Reich. Absolutely not. What I'm interested in is the analogy of principle.
It's a principle which could leave some senior administration figures in jeopardy if they travel abroad. Diane Beaver, the military lawyer left exposed at the bottom of the chain, says for her part she was doing her duty.
The Attorney General and others looked at it and made the decision, and the President issued the order. And so for me, the Commander-in-Chief issued that order, and it was for me to follow.
That was Diane Beaver talking to Peter Marshall. Well, David Rifkin is a former White House legal advisor, and he joins us from Washington. David Rifkin, thanks very much for joining us. Here is a junior lawyer who was basically given the job of deciding what interrogation techniques were allowed. It's astonishing, isn't it?
It's not, I would say, the whole account about how the advice by the more senior lawyers relative to applicability of Geneva relates to the permissible interrogation techniques is, let's just say, is not as simple and clear-cut as Philippe has alleged in his article, which I've read with interest. Look, we're talking about people who, in good faith, were trying to wrestle with very difficult, unprecedented legal issues. And the great thing about the United States, and I would submit to you that we're one of the very few countries who do that, is lawyers ask difficult questions and sketch answers that may be displeasing to some, but doing it in good faith to try to come up with whatever legal parameters. There's nothing wrong with that. I would rather do that than have people. I mean, I would very much doubt, for example, that the French government asked for legal advice when they went and blew up the Rainbow Warrior, which was a Greenpeace ship in New Zealand.
But let's just go back to this point. It wasn't just Philippe Sands. She was the lawyer who was the only one who wrote a legal opinion. She was at the bottom of the rung, and that went straight to Rumsfeld, who signed it off. As she said, she was left on a tiny end of the limb, hung out to dry.
Well, that's manifestly untrue. If you look at other documents, there was a task force within the Department of Defense chaired by a number of senior lawyers. There were legal memos beyond the memo on the applicability of Geneva Conventions that dealt with the permissible parameters of interrogation techniques. Philippe Sands makes her sort of out to be the only person. That is just absolutely not true. But the big picture issue is this. There were unfortunately some abuses that, in my opinion, and the opinion of every independent commission that looked at it, had nothing to do with the big policy cuts. What Philippe Sands does, it links the big policy decision about Geneva Conventions not applying to Al-Qaeda, which, by the way, in my opinion, is absolutely correct because it's not a state, it is not a state party, and unfortunate things that happen in Abu Ghraib and Guantanamo.
But extraordinary.
And they're just apples and oranges. Extraordinary
that the US Supreme Court back in 2006 said the Geneva Convention did apply. And you've written today in the Wall Street Journal, to the extent that international law can be made, it's made through actual state practice. Now, what kind of rules does that set you? Nothing.
No, each state is supposed to be acting in good faith and construing and fleshing out its international legal obligations. By the way, we don't have time to get into it, but trust me, I've read the decision you're talking about, Hamdan decision. The Supreme Court did not come anywhere close to saying the Geneva Conventions, quote, applied for all purposes to the detainees in Guantanamo. The Hamdan decision had to do with one narrow issue, how you structure the workings of military commissions. So there's just so much misinformation, and facts matter a great, and nuances matter a great deal in law.
Okay, I guess we'll have to agree to differ on that one point. We've run out of time, but David Rifkin, thanks very much indeed.
To be with you.